Hello students, welcome to Skholar, your one-stop solution for IAS preparation. Students, my name is Anubhav Sharma and I am your faculty for Indian Polity, and in this module we'll be studying about fundamental rights. In fact, this will be the first lecture in the series of lectures that we will be having dedicated for fundamental rights. So students, in this module, as I have just discussed, we'll be studying about fundamental rights. This is first among the series of modules that we will be having for fundamental rights. Now, the first thing with respect to fundamental rights is for us to understand some very important basic things about fundamental rights. What exactly are fundamental rights? Why exactly do we need it? So on and so forth. So coming to the introduction part, fundamental rights are one of the salient features of the Constitution. It is pretty certain that fundamental rights are one of the most important aspects of Indian Constitution. We know that it is part 3 of Indian Constitution, which is listing fundamental rights. So it is in the part 3 of Indian Constitution. Constitution is essentially doing what? It is essentially setting limits on the powers of the government and ensuring that every citizen should enjoy certain rights. Now students, with respect to this point, we have already discussed it in some of our previous modules. We had discussed that essentially fundamental rights are a way in which the constitution makers were able to protect the future generations, the future generation of Indians. From what exactly were they trying to protect the future generations from? Essentially, what we know is the fact that government has been authorized by the Constitution in order to exercise authority, in order to exercise power. Now, certainly it cannot be that in a democracy, government in itself becomes tyrannical, government in itself starts acting in a manner in which they are compromising some of the basic rights of the people. Keeping that in mind, essentially what was required was to enlist a set of rights, a bill of rights that could be provided to every citizen of India, and given the instruction should be given to the parliament or to the executive that you cannot act in any manner, be it in your legislative capacity of making a law or for that matter in your executive capacity of being a government, which is contravening with these fundamental rights. तो essentially हुआ क्या? जो कॉन्स्टिट्यूशन मेकर्स थे उन्होंने संविधान में फंडामेंटल राइट्स रखे. ये जो अधिकार जो हर नागरिक को दिए गए, इसमें बात क्या थी? बात इतनी थी कि ये चीज संविधान में लिख देने से अब ये चीज क्लियरली कम्युनिकेट हो गई लेजिस्लेचर को जो कानून बनाते हैं या फिर एग्जीक्यूटिव को जो कि गवर्नमेंट होती है कि आप कोई भी एक्ट, कोई भी एक्शन इस तरीके से नहीं कर सकते जहां पे आप इन मौलिक अधिकारों का हनन करें, जहां पे आप इन फंडामेंटल राइट्स को वॉयलेट करें. इस चीज को लिख देने से हम लोगों ने एक डिस्पोटिक गवर्नमेंट की पॉसिबिलिटी से लोगों को बचा लिया. आई होप दिस पॉइंट इज क्लियर. नाउ वी कम टू द एवोल्यूशन ऑफ फंडामेंटल राइट्स. द फर्स्ट थिंग इज what all were the global influences that led to evolution of fundamental rights in India. Well, when we were to look at history, what exactly do we see? That fundamental rights first originated in Western countries. In fact, if we were to see some of the examples, what do we see? England's Bill of Rights of 1689, United States Bill of Rights of 1787, and France, that is the country France, Declaration of Rights of Man are some of the first few examples of fundamental rights being granted to the citizens of that country. So what exactly do we see? That when the constitution makers were making the Constitution of India, they actually had the benefit of history. They actually had some of the constitutions which had included fundamental rights within them. We had the examples of England's Bill of Rights. We have the examples of United States Bill of Rights of 1787 and of course France's example of Declaration of Rights of Man. So while making the constitution makers did pay good attention to all these constitutions. Coming to Indian freedom struggle, that is Indian freedom struggle also played an important role in the evolution of fundamental rights. How exactly did that happen? We have studied in modern history about Rowlatt Act of 1990. What exactly was Rowlatt Act? All we need to keep in mind is that civic liberties of the people were compromised by several actions which were taken by the British government, and during that time, the demand for civil rights and limitations on the powers of the government rose. because essentially government was acting in a despotic manner. The reasons need not be given by the government in order to arrest someone. As such, there is nothing called judicial protection from excesses done by the executive. Keeping that in mind, Rowlatt Act of 1919 was criticized, and a debate had started in India where people of India, Indian National Congress, were asking for Bill of Rights for every citizen of India. तो ये एक भारत की फ्रीडम स्ट्रगल का एक एग्जाम्पल है जहाँ पे फंडामेंटल राइट की बात चालू हुई. Then we have also studied about 1928 Nehru Report. It was in fact the first Indian attempt to include universal adult suffrage, religious and minority rights, limitations on the power of government. This again is a very important example here. 1928 में नेहरू रिपोर्ट आई थी. नेहरू रिपोर्ट क्या थी? जैसे कि आप जानते हैं कि साइमन कमीशन के आने के बाद ब्रिटिश गवर्नमेंट ने, ब्रिटिशर्स ने चैलेंज किया था इंडियन नेशनल कांग्रेस को, क्या आप अपना एक संविधान ला सकते हैं? कैन यू ब्रिंग योर ओन कॉन्स्टिट्यूशन? टू दैट Indian National Congress came up with something called Nehru Report. This Nehru Report is called Nehru Report because the chief architect was Motilal Nehru. इस रिपोर्ट में अगर हम गौर से देखें, हम क्या देखते हैं? There were provisions with respect to universal adult suffrage. There were provisions with respect to religious and minority rights. There are in fact provisions with respect to limitations on the powers of government, and all of them actually find its place in the fundamental rights that we see today. So this again acts as a very important example of India's freedom struggle acting as a source for evolution of fundamental rights. Then we also have Karachi session of 1931. What exactly has happened then? Congress passed a resolution demanding fundamental rights for the people. So a resolution got passed in this landmark session of Karachi session in 1931 when for the first time Indian National Congress demanded for fundamental rights for the people. Then, if we were to understand what were the rights they were demanding, it included several aspects like civil rights, socio-economic rights, minimum wage, and abolition of untouchability and serfdom. So essentially, all these rights, when we look at the fundamental rights one by one, all of these aspects has actually been covered in the fundamental rights that we have provided. The idea of minimum wage, if you were to think about, was mainly derived because of the Russian Revolution that had happened, evolution of international labor organization that was happening during the same time. तो वो एक बहुत बड़ा मुद्दा बन गया था उस टाइम पे. इसलिए minimum wage as a system, as a fundamental right that should be provided to the citizens was included here. But when we talk about Indian Constitution, we know minimum wage fundamental rights में तो नहीं आता है, but directive principle of state policy में जरूर आता है. Then we also have 1948 UN General Assembly, which had adopted something called Universal Declaration of Human Rights. What exactly are these Universal Declaration of Human Rights? Essentially 1948 में हुआ ये कि जो UN General Assembly थी, उन्होंने decide किया that there are something called human rights. What are human rights? The rights which every human has by virtue of being born as a human. It doesn't matter if you come from one country or another country. It doesn't matter if you belong to one race or the other race. It doesn't matter if you are a male or female. All that matters is that you are human, and there is something called universal human rights. So when these universal human rights were declared, what we essentially see is that it includes some of the elements of the fundamental rights which every citizen of the globe has, which every person who is living in the world has. This again can be seen as one of the ways in which fundamental rights got evolved. I hope this point is clear. Now let's try to understand what exactly do we mean by Bill of Rights. While it is not that important, but since students get confused in it is why I decided to include it here. The list of rights mentioned and protected by the Constitution is called Bill of Rights. So essentially what we are trying to say when we say Bill of Rights, कि ये वो अधिकार है जो संविधान आपका प्रोटेक्ट करेगा. कहने का मतलब क्या है? That it is not necessary that rights of a person is limited only to fundamental rights. There are rights, there are other rights like legal rights. For example, you have a legal right of inheritance, you have several other legal rights, you have legal right in form of right to information, MG Narega, right to work. So there are other forms of rights which cannot be called as fundamental rights. But when we talk about Bill of Rights, what exactly are we trying to say? That these are those rights which the Constitution is protecting, which the Constitution is mentioning. I hope this point is clear, that Bill of Rights pertains to those set of rights which are mentioned in the Constitution. and which gets protected by the provisions given in the Constitution. Thus, it prohibits government from acting against the rights of the individuals and ensures a remedy in case there is a violation of these rights. तो एक तरफ वो क्या करता है, वो ये कहता है कि सरकारों को अधिकार नहीं है कि वो किसी भी तरह से एक्ट करे जहां किसी के मौलिक अधिकारों का हनन हो. Government of the day does not have the power, does not have the authority to act in a manner in which it is violating the fundamental rights of the citizens. Secondly, it should also mention the remedy. What is remedy? Let's say government has made such a law by which fundamental right of a person is getting violated. In such a situation, Constitution will also mention the remedy that can be exercised by a citizen कि अगर आपके fundamental right को breach किया गया है, आप सुप्रीम कोर्ट जा सकते हैं, आप हाई कोर्ट जा सकते हैं, या फिर एक रेमेडी आपको दे दी गई है कि अगर ऐसा होता है, दिस इज द रेमेडी दैट यू कैन एक्सरसाइज. These rights are enshrined in Part 3 of Indian Constitution that we have studied. What all are the articles that are covering fundamental rights of Indian Constitution? These are Articles 12 to Article 35, and these are called as fundamental rights. Another important point to note, and this is something that has been asked in several previous examination, that these set of rights from Article 12 to 35 of Part 3 of Indian Constitution, which pertains to fundamental rights, are also described as the Magna Carta of India, and it contains comprehensive list of justiciable fundamental rights. What is justiciable fundamental rights? Those rights which a person can get enforced. That is, it cannot be that your fundamental rights are getting breached, and you, if in that event, you can actually approach judiciary and get remedy for it. तो ये होते हैं justiciable rights. I hope this point is clear. Essentially हमको क्या याद रखना है? Bill of Rights वो set of rights है जो Constitution में दिए गए हैं. ये वो rights है जिसको Constitution protect करता है. जब भी ये राइट्स देगा कॉन्स्टिट्यूशन आपको रेमेडी भी प्रोवाइड करता है. दैट इज, अगर आपके ये राइट ब्रीच हो रहे हैं, यू कैन अप्रोच जुडिशरी. और व्हाट एग्जैक्टली इज द रेमेडी इन प्लेस? जब हम भारत के संविधान की बात करते हैं, वी हैव पार्ट 3 ऑफ इंडियन कॉन्स्टिट्यूशन, आर्टिकल 12 टू आर्टिकल 35 इस पार्ट 3 में आता है. एसेंशियली इस पार्ट में फंडामेंटल राइट्स रखे गए हैं. एक और बात जो हमें ध्यान रखनी है कि इन सेट ऑफ फंडामेंटल राइट्स को हम मैग्ना कार्टा ऑफ इंडिया भी कहते हैं. And this again is something which is important for your PCS exams. Now we come to the next part, and here we'll be discussing about Article 12. As we have discussed in our previous slide, that from Article 12 to Article 35 we have fundamental rights. So let us start with Article 12 here. What does Article 12 says? It essentially gives the definition of state. The term state has been used in different provisions concerning the fundamental rights. Article 12 have defined the term for the purposes of Part 3 as explained in the diagram. So what exactly is Article 12? Essentially what we see is that in fundamental rights mentioned in Article 12 to Article 35, the term state has been used. What exactly does this term state mean? Article 19 says, for example, that state cannot act in a manner in which someone's freedom of expression is getting violated. But the question is, who is state? What exactly is state? How exactly do we identify if the act done by any of the body amounts to state or not? इसलिए इस चीज को ध्यान में रखते हुए कॉन्स्टिट्यूशन मेकर्स ने आर्टिकल 12 रखा, जहां उन्होंने स्टेट को डिफाइन कर दिया. नाउ व्हेन वी लुक एट आर्टिकल 12, व्हाट एग्जैक्टली डू वी सी? दैट इन द मीनिंग ऑफ स्टेट इंक्लूड्स स्टेट एग्जीक्यूटिव एंड लेजिस्लेचर, यूनियन एग्जीक्यूटिव एंड लेजिस्लेचर, लोकल अथॉरिटीज, statutory and non-statutory bodies of the government, private body which is an instrument of the state. Let me again explain it to you. Article 12 बताता है वो सारी bodies, वो सारे institutions जो state form करेंगे. जो Article 12 state की definition दे रहा है, तो state में क्या क्या आता है वो बताएगा Article 12. तो वो क्या बताता है? Union executive and legislature state है. Union executive मतलब union government, legislature मतलब parliament. वो ये भी कहता है कि स्टेट एग्जीक्यूटिव एंड स्टेट लेजिस्लेचर वो भी स्टेट की डेफिनेशन में आते हैं. ऑल द एक्ट्स डन बाय स्टेट गवर्नमेंट और फॉर दैट मैटर स्टेट लेजिस्लेटिव असेंबली, जो भी वो बिल्स पास करेंगे वो भी एक्ट ऑफ स्टेट माना जाएगा. वो ये भी बताता है कि जो लोकल अथॉरिटीज होती है, फॉर एग्जाम्पल पंचायत हो गई, फॉर एग्जाम्पल कॉर्पोरेशन हो गए, इनको भी स्टेट में माना जाएगा. वो ये कहता है अगर स्टैट्यूटरी बॉडीज है और नॉन स्टैट्यूटरी बॉडीज है, स्टैट्यूटरी बॉडीज मतलब वो बॉडीज जिनके लिए एक एक्ट पास किया गया है, एक बिल पास किया है, नॉन स्टैट्यूटरी बॉडीज जो सिर्फ एक एग्जीक्यूटिव एक्शन से बनाया गया है, फॉर एग्जांपल नीति आयोग, इट हैज बीन मेड cut the last 10 seconds. So statutory bodies and non-statutory bodies, जो bodies जो एक statute के बिना पे बनी गई हैं वो statutory bodies है, और जो bodies जो non-statutory bodies वो bodies हो जाती है जो उस पे बनी गई है, that is for which an act has not been passed by the parliament. Then we have private body which is an instrument of state, that is अगर कोई private body है और वो private body is acting on the directions of the state, that is direction of any of these bodies, then even the actions done by that private body will be also taken as an act done by state. तो ऐसा नहीं हो सकता कि एक प्राइवेट बॉडी को स्टेट ने डायरेक्शन दिया और प्राइवेट बॉडी ने इस तरीके से काम किया कि किसी के फंडामेंटल राइट्स ब्रीच हुए तो वो सिटीजन ये मान सकता है कि ये एक्ट स्टेट ने किया है एंड स्टेट डज नॉट हैव द पावर टू डू सो. आई होप दिस पॉइंट इज क्लियर. Students, with respect to Article 12, the most important thing that you need to keep in mind is this diagram. Just try to keep in mind everything that gets included in Article 12, that is in the meaning of state. बहुत simple रखिए approach. Union government, union legislature, ये दोनों आ जाते हैं. State government, state legislature, ये आ जाते हैं. Third tier भी है, local authorities, वो भी आ जाती हैं. Statutory bodies, non-statutory bodies भी आ जाती हैं, और ये key point है private body, which is an instrument of state, right? Now we come to Article 13. What is Article 13? Article 13 declares that all laws that are inconsistent and with any of the fundamental rights shall be void, and this article mainly deals with the constitutional laws. What exactly are we trying to say here? Essentially, we have Article 13, which clearly specifies something, which says that अभी आप जो देखने वाले हैं इस Part 3 में, आप देखने वाले हैं fundamental rights. From Article 14 onwards, we will be looking at every fundamental right that a citizen of India has been given. Before we get into that, let us make one thing very clear कि जो भी rights अब आप देखेंगे 14 से 32 के बीच में, ये सारे rights implement होना जरूरी है, enforce होना जरूरी है, और हर वो action जो state लेता है जो इन rights को breach कर दे, जो इन rights को violate कर दे, उस एक्शन को void माना जाएगा, उन एक्शन को गलत माना जाएगा. I hope you are able to understand how exactly the constitution makers has gone about it. What exactly have they done? पहले उन्होंने आर्टिकल 12 में बता दिया what exactly do we mean by state. फिर उन्होंने आर्टिकल 13 में ये बताया कि भाई देखो जो भी आर्टिकल्स, जो भी राइट्स हम जो पार्ट 3 में रख रहे हैं, वो जो आर्टिकल्स है, वो जो राइट्स है, उनको किसी भी तरीके से वॉयलेट नहीं किया जा सकता. These set of rights cannot be violated by any of the act done by government or legislature. अगर कोई ऐसा एक्ट होता है उस एक्ट को void मान लिया जाएगा, right? इसमें एक और बात जो ध्यान रखने की है, आर्टिकल 13 is also serving another purpose, and that is कि भारत जब आजाद हुआ था, at the time when India got independence, there were certain rules, there were certain laws that were enforced, that were in play. Those set of laws which are in violation to fundamental rights of the people, all those laws are now invalidated, are now void. This again is a purpose which Article 13 is serving. I hope this point is clear. What exactly are we trying to say? कि इंडिया 1947 जब आजाद हुआ तो जो कानून व्यवस्था ब्रिटिश सरकार ने स्थापित की थी, the law and order administration, the legal system, the Indian penal code, which was established by the British government, that was still in place, that was still implemented. All the people of India would need to follow it. But जब आर्टिकल 13 आ गया तो ये बात क्लियर हो गई कि जितने भी पुराने कानून हैं, जो हर वो कानून जो किसी के फंडामेंटल राइट को वायलेट करता है, वो अब वैलिड नहीं है, वो अब वॉइड है, वो अब इनवैलिड है. आई होप दिस पॉइंट इज क्लियर. Then there are two doctrines which are important for us to remember here. There is something called doctrine of eclipse and there is something called doctrine of severability. What is doctrine of eclipse? Let's try to understand that Article 13 is based on doctrine of eclipse. What exactly does it say? That a pre-constitutional law that is inconsistent with the fundamental right will become dormant and it does not cease to exist. However, it can come back when the constitution is amended. Essentially, what we are trying to say is that there is something called doctrine of eclipse. What it means is कि हर वो कानून जो संविधान से पहले बनाते हैं, every law that was made before the constitution, that law will become dormant because it is in violation of fundamental rights. By dormant, what we mean is it's not that it has been removed from the Indian Penal Code or CRPC or anywhere. It's just that it will not be implemented anymore. It cannot be implemented anymore. It will be in a state of dormancy. But if any kind of amendment that has been done to the constitution, then the same law can again become active. That is, if in future an amendment has been done to fundamental rights in a manner in which the violation which the act had with respect to that fundamental right is no longer valid, the law will again become active. I know थोड़ा confusing हो रहा है, इसको मैं आसान तरीके से समझा देता हूँ. Let's say there is a law, इस law को हम बोलते थे law X, right? मान लेते हैं जो ये law X था, ये बना था कॉन्स्टिट्यूशन आने के पहले. जो law X आपके कॉन्स्टिट्यूशन आने के पहले बना है, उसमें कुछ स्पेसिफिक्स होंगे. मान लेते हैं वो जो स्पेसिफिक्स थे वो आर्टिकल 14 का वॉयलेशन कर रहे थे. ठीक है, अगर आर्टिकल 14 का वॉयलेशन कर रहे हैं तो ये जो लॉ एक्स था अब ये डॉर्मेंट स्टेट में चला जाएगा. ये रिमूव नहीं हुआ है, ये रिपीट नहीं हुआ है, जस्ट दैट अब ये लॉ एक्स वैलिड नहीं है फॉर इम्प्लीमेंटेशन. राइट, मान लेते हैं आगे चल के 10 साल 15 साल बाद आर्टिकल 14 में इस तरीके का अमेंडमेंट हुआ जिसकी वजह से जो लॉ एक्स था वो जो आर्टिकल 14 को वॉयलेट कर रहा था वो अब नहीं कर रहा. तो ऐसी परिस्थिति में, ऐसे सिचुएशन में हुआ क्या, लॉ एक्स अगेन इम्प्लीमेंटेबल हो जाएगा, लॉ एक्स अगेन वैलिड हो जाएगा. दिस इज व्हाट वी मीन बाय डॉक्ट्रिन ऑफ एक्लिप्स. आई होप दिस पॉइंट इज क्लियर. Then we have doctrine of severability. What exactly does this doctrine says? Doctrine of severability says that only those parts of the constitution, those parts of the law can be invalid which violate the constitution. But the severability should not change the intent of law, otherwise entire law is held invalid. Let me just explain it. What exactly does it say is कि जब हम constitution में fundamental rights रखते हैं, what exactly are we saying? What we are trying to say is that any law which has been made by the legislature, if it is in violation to fundamental right, that law is invalid. But a law that has been made by the legislature may not in its intent be violative of fundamental right, but some of its aspects can be violative of fundamental rights. Let me give you a very simple example of Aadhaar law. जो आधार का प्रोविजन था, जो आधार जिस तरीके से इम्प्लीमेंट हो रहा था, जब इसको सुप्रीम कोर्ट की संज्ञा में लाया गया, when it was brought to the notice of Supreme Court, essentially what Supreme Court did was to look at Aadhaar law from standpoint of its intent, from standpoint of its utility, and the modulus operandi in the specifics in it. What it did was to separate those aspects of the Aadhaar law which were in violation of several aspects of Indians' fundamental rights, be it Article 21, Article 19, Article 15, so on and so forth. उन्होंने उन सारे प्रोविजंस को हटा दिया कि जो उनको लगा आधार लॉ में वॉयलेटिव है भारत के जो मूल अधिकार है, जो मौलिक अधिकार है एक नागरिक के, और जो बाकी चीजें जो वॉयलेटिव नहीं है फंडामेंटल राइट्स के, उनको रहने दिया, उनको रिमेन रखा, उनको इंटैक्ट रखा. एसेंशियली उन्होंने क्या किया, उन्होंने फॉलो किया डॉक्ट्रिन ऑफ सेवरेबिलिटी. क्या कहता है ये डॉक्ट्रिन? वो ये कहता है कि जब भी कोई लॉ का कोई स्पेसिफिक वॉयलेटिव हो जाता है फंडामेंटल राइट के, ओनली दैट स्पेसिफिक ऑफ दैट लॉ नीड्स टू बी रिमूव्ड. लेट मी जस्ट गिव यू अनदर एग्जांपल सो दैट देयर इज नो कंफ्यूजन. मान लेते हैं कोई कानून है जिसमें 5 बातें लिखी गई है, लेट्स से A, B, C, D, E. इसमें से जो D वाली बात थी सिर्फ वो ऐसा एस्पेक्ट था, वो इस लॉ का ऐसा फीचर था विच इज वॉयलेटिव ऑफ एनी ऑफ द फंडामेंटल राइट्स. डॉक्ट्रिन ऑफ सेवरेबिलिटी बस इतना कहता है कि पूरे कानून को हटाने की जरूरत नहीं है. A, B, C and E can remain intact. All that we need to remove is the D provision of the law. I hope this point is absolutely clear now. Now, another important thing that we need to keep in mind is that Article 13 is also providing for the doctrine of judicial review. What exactly is Article 13 saying? जैसे कि हमने बोला, every law, every act done by the state which is in violative of the fundamental rights will be held void. But who exactly will decide जो सरकार ने एक्शन लिया है और फॉर दैट मैटर जो लेजिस्लेचर ने कानून बनाया है वो वॉयलेटिव फंडामेंटल राइट के है या नहीं? इसके लिए कॉन्स्टिट्यूशन ने कहा ये काम करेगा सुप्रीम कोर्ट, ये काम करेगा जुडिशरी. Thus, what exactly are we saying? That the review power with respect to laws made by the legislature or the actions done by the executive in their capacity of being the government, that will be reviewed by the judiciary. दस जुडिशियल रिव्यू का जो डॉक्ट्रिन है, जुडिशियल रिव्यू का प्रोविजन है, वो आर्टिकल 13 से अपनी लेजिटिमेसी डिराइव करता है. सुप्रीम कोर्ट अंडर आर्टिकल 32 and high courts under article 226 can declare a law unconstitutional and invalid on the grounds of contravention of any of the fundamental rights. अगर किसी के मौलिक अधिकारों का हनन होता है तो वो अपने आर्टिकल 32 को एक्सरसाइज करता हुआ सुप्रीम कोर्ट तक जा सकता है, कह सकता है कि मेरे आर्टिकल 32 मेरे फंडामेंटल राइट का ब्रीच हुआ है, प्लीज आप मुझे रेमेडी दीजिए. या फिर आर्टिकल 226 जो हम पढ़ेंगे जब हम हाई कोर्ट के बारे में पढ़ेंगे, वो भी ये प्रोविजन देता है जो कहता है कि आप हाई कोर्ट जा सकते हैं अगर आपके किसी भी मौलिक अधिकार का हनन हुआ है. If your fundamental rights has been breached in any manner, you can exercise your article 226 and go to high courts. I hope this point is also clear. Now, what exactly does a law include? This again is something that we need to understand. For the reason the debate around Article 13 has been around the understanding of law. Article 13 क्या कहता है? हर वो law which is violative of fundamental right, any act done by the state which is violative of fundamental right cannot be allowed and that will be held void. But then what exactly do we mean by law? ये समझना जरूरी है, क्योंकि लॉ में क्या आता है क्या नहीं आता है. अगर हमने इसको ये समझा तभी हम ये समझ पाएंगे जुडिशियल रिव्यू की पावर क्या है. इसको साफ भाषा में if we were to understand in simple terms, that any law made by the legislature or executive which is violative can be held void by the Supreme Court. But वैसे कौन से एक्ट्स है जिनको लॉ नहीं कहा जा सकता? There could be certain functions which legislature is doing that functioning cannot be called as law. अगर हम लॉ की डेफिनेशन को समझ पाते हैं तभी हम समझ पाएंगे कि जुडिशियल रिव्यू उस लॉ पे या उस फंक्शनिंग पे अप्लाई होगा या नहीं. The term law of in Article 13 has been given wide connotation to include the following. What exactly does the law include? First, Parliament and state legislature laws. Then ordinances that has been passed by the executive, be it the state executive or for that matter the central executive. Ordinances के बारे में हम पढ़ेंगे. Essentially होता क्या है? That one way in which the law making can be done is by the use of legislature, that is जो भी legislature pass करता है, legislative assembly, or for that matter जो parliament, वो से law making होती है. But it may very well be क्योंकि parliament is not in house, parliament house is not working right now, तो हमें कुछ immediate स्टेप्स लेने पड़ेंगे, एक इमीडिएट कानून बनाना पड़ेगा, तो उस कानून को ऑर्डिनेंस कहा जाता है. जब हम ऑर्डिनेंस के बारे में पढ़ेंगे तो हम ये भी जानेंगे कि ऑर्डिनेंस को रेटिफाई करना पड़ता है पार्लियामेंट को, देन ओनली कैन ऑर्डिनेंस सरवाइव. ज्यादा परेशान होने की बात नहीं है, जब हम लोग ऑर्डिनेंस के बारे में पढ़ेंगे तो ये एब्सोल्युटली क्लियर हो जाएगा. अभी व्हाट वी नीड टू अंडरस्टैंड दैट व्हेन वी टॉक अबाउट लॉज, we need to include laws made by parliament and state legislature, and it also includes ordinances. Then laws also include order, bylaws, rule, regulation or notification which is being done by state, and it also includes customs having the force of law. अब आपके मन में सवाल आएगा, what exactly do we mean by customs? Customs या कहने का मतलब यह है कि ऐसा भी हो सकता है that there are certain conventions which are being followed by the state, be it at the level of the parliament or for that matter even at the level of the bureaucracy. तो ऐसे कन्वेंशन से जो फॉलो हो रहे हैं, ये कन्वेंशन किसी लॉ से लेजिटिमेसी नहीं लेते हैं या कोई नोटिफिकेशन या कोई एग्जीक्यूटिव ऑर्डर नहीं पास हुआ था, बस एक प्रैक्टिस थी जो चली आ रही थी. तो इस प्रैक्टिसेस को कस्टम कह दिया है कॉन्स्टिट्यूशन ने, और कहा है कि इवन दोज कस्टम्स विच आर बीइंग प्रैक्टिस्ड बाय स्टेट फॉर विच देयर इज नो लेजिस्लेचर और फॉर दैट मैटर देयर इज नो एग्जीक्यूटिव ऑर्डर, वो सारे कस्टम्स और कन्वेंशंस भी लॉ की डोमेन, लॉ की अंडरस्टैंडिंग में आते हैं. राइट, अब बात क्या आती है, एंड दिस इज अ वेरी इंपॉर्टेंट पॉइंट स्टूडेंट्स, दैट आर्टिकल 13 is also mentioning that constitutional amendment is not a law and hence cannot be challenged. Now we know that India's constitution also gave constitutional amendment powers to the parliament. अब जब constitutional amendment प्रोसेस करते तो essentially करते क्या है, पहले एक बिल आता है, फिर बिल को पास किया जाता है, फिर वो एक्ट बनता है जिसको कॉन्स्टिट्यूशनल एक्ट कहते हैं, फिर कॉन्स्टिट्यूशन का अमेंडमेंट होता है. नाउ द क्वेश्चन इज, डज दैट ऑल्सो अमाउंट टू एज अ लॉ? क्या ये भी एक लॉ है? क्योंकि अगर एक लॉ है तो essentially what it means is that constitutional amendment cannot be done in a way in which it is violative of fundamental rights. I hope you are able to understand the problem or understand the confusion here. What exactly is the confusion is कि ऐसा नहीं होना चाहिए कि लॉ की भाषा में हम कॉन्स्टिट्यूशनल अमेंडमेंट को भी रख लें, क्योंकि अगर हम रख लेते हैं तो एसेंशियली व्हाट वी आर ट्राइंग टू डू इज कि कॉन्स्टिट्यूशनल अमेंडमेंट भी अगर लॉ हो गया तो जुडिशियल रिव्यू कॉन्स्टिट्यूशनल अमेंडमेंट को स्ट्राइक डाउन कर सकती है, जबकि कॉन्स्टिट्यूशनल अमेंडमेंट इज फाइंडिंग इट्स लेजिटिमेसी फ्रॉम वन ऑफ द प्रोविजन ऑफ द कॉन्स्टिट्यूशन। लेकिन इस चीज में सुप्रीम कोर्ट ने अपना इंटरप्रिटेशन दिया है और उन्होंने इस चीज को क्लियर किया है कि इवन इफ an act has been done, a law has been passed by the Constitution Assembly, by the Parliament, that amounts to a constitutional amendment, but that constitutional amendment is violating fundamental right, that constitutional amendment can also be stopped. कहने का मतलब ये है कि जहां आर्टिकल 13 को हम पढ़ते हैं तो एक सेट ऑफ एक्सपर्ट्स ये मानते हैं कि कॉन्स्टिट्यूशनल अमेंडमेंट इज नॉट अ लॉ, and since it's not a law, it does not come under the review or judicial review of the Supreme Court. दूसरे सेट ऑफ एक्सपर्ट्स ये मानते हैं कि नहीं, even constitutional amendment that is affecting someone's fundamental right can also come under the purview of judicial review. इसी चीज पे सुप्रीम कोर्ट ने क्लैरिटी दे दी है कि हाँ, अगर कोई कानून बनाया गया है और वो कानून असल में जो कॉन्स्टिट्यूशनल अमेंडमेंट है तो उसको कानून ही माना जाएगा और वो जुडिशियल रिव्यू के अधीन आता है। इसी पे एक लैंडमार्क जजमेंट है केशवानंदा भारती जजमेंट, जिसको हम लोग जब जुडिशरी को पढ़ेंगे तो उसको डिटेल में समझेंगे। एसेंशियली वो क्या कहता है, वो यही कहता है that there is something called basic structure in Indian Constitution which cannot be violated, and whenever this basic structure is getting violated by any of the amendment done by the legislature, then judiciary can step in and can stop that amendment to get passed. अब हम एक ओवरव्यू ले लेते हैं with respect to the fundamental rights that are included in the part 3. So we have article 14 to 18 which includes right to equality. We have article 19 to 22 which includes right to freedom. We have article 23-24 that includes right against exploitation. Then we have right to freedom of religion, cultural and educational rights, right to constitutional remedies, that is article 32 to article 35. Students, in the upcoming lectures we'll actually take them one by one in every module and we'll cover them all, so you don't really have to worry about everything that is important will get covered, right? So students, what exactly have we studied in this lecture? We studied about article 12, we studied about article 13. Article 12 essentially gives us the understanding of what exactly do we mean by state, and article 13 what exactly we understood, that any act done by the state which is in violation of the fundamental rights will be held as void. हमने ये भी समझा that there is something called Bill of Rights. हमने समझा कि the provision, that is doctrine of judicial review, is actually deriving its legitimacy from article 13, क्योंकि article 13 कहता है कि हर वो एक्ट जो लेजिस्लेचर और फॉर दैट मैटर एग्जीक्यूटिव करता है, जो फंडामेंटल राइट्स को ब्रीच करता है, वॉयलेट करता है, वो वॉइड होगा। बट ये कौन डिटरमाइन करेगा? ये जुडिशरी डिटरमाइन करेगा, ये आर्टिकल 13 बता देता है। हमने एक ओवरव्यू भी ले लिया विद रिस्पेक्ट टू द राइट्स व्हिच आर इंक्लूडेड। अब ये जो सारे राइट्स है ये हम एक एक करके अपने आने वाले अपकमिंग मॉड्यूल्स में कवर करेंगे। दिस इज ऑल स्टूडेंट्स वी हैड फॉर दिस लेक्चर। इफ यू हैव एनी डाउट्स प्लीज आस्क अस। For more such videos, please log on to Skholar. Thank you.